Welcome to this call. You are amongst the almost 30,000 people who registered for this call. We ran out of capacity for a Zoom call at like 20,000. So we're having to set up another forum. This is the most high stakes time, not just for education, for our country that I can remember. That we're living through an interesting and scary piece of history here. And you know why you wanted to be on this call. You have a million questions. Maybe you're a leader, a local or a state leader, or a national leader, and you've got people asking you questions. So in districts across this country, some of our local affiliates have reported really good cooperation with their district administration. They're feeling included in the planning. They're looking at the risks of possible creative solutions. Some of those solutions are risky. And so they're talking about it, and they're getting help from school nurses and counselors and local health officials. And other locals, not so much. They're fighting their administrators. They're feeling completely excluded from the process. So it really depends on where you are, whether or not you feel that there is some control here. NEA has been sending out the guidance that we have continually been getting updated from health experts. What educators should know about what they need to demand is in their schools, whether or not educators are helping to design some creative solutions to distancing kids. I had 39 sixth graders. You were not going to get 39 sixth graders in my classroom 6 feet apart, physically impossible. But creative split sessions, using portable classrooms. A lot of people are at least talking about possibilities. It's all so complicated. It might work well somewhere and be a disaster somewhere else, depending on where you live, and depending on what's happening with the rate of infection itself. And then, if that wasn't all enough, this week, we got more medical advice from Donald Trump and Betsy DeVos. Can I just say this, and I really can't say it enough? It is never a good idea to take medical advice from Donald Trump or Betsy DeVos. They have ordered, with no authority to do so, that no, forget about split sessions, forget about maybe some kids will still be virtual or some hybrid model, and not because it's bad for kids. They have said, no, all schools will open for all students who have to be there all day with no exceptions. And if you don't do it that way, then we will withhold federal funding for districts who do not obey. Think about the federal funding your school district gets. Federal funding goes to the most vulnerable students. It goes to our special ed students. It's a school lunch program. It's English language learners. It's Title I schools for kids that live in poverty. So do it this way, whether it's safe or not, or we'll take your special ed funding. So yeah, I want you to know that we have taken every opportunity to go to every news source that would take our calls to explain and remind them that Donald Trump has a medical degree from Trump University. So please take that into consideration. And that we have very strong guidance, and we didn't make it up. Infectious disease medical professionals said that there's an absolute precondition to even think about reopening schools, and you have to meet the safety guidelines. Number one, that testing in your community shows a consistent decline in the infection rate. You know that some places are going up. And they say there has to be a way to distance. There has to be the PPE, the masks, the gloves. There has to be very specific disinfectants. And you're going to be disinfecting surfaces that little kids with sticky fingers that rub their noses touch all the time. And we have to be trained on that. There has to be all hands on deck. You cannot start laying off millions of teachers and support professionals. You cannot do this without everybody plus. And you know that the funding for so many of our schools has fallen off a cliff. So at a time when we need more funding just to keep what we had, they're talking about punishing us by giving us less. None of what we need to do is free. I did have a reporter who kind of rolled his eyes on a Skype call and said, now, why is it with you guys that it all comes down, it's all money, 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 money. You could do some creative things with plexiglass if you put them on students' desks. And I went, oh, please tell me where they're giving away plexiglass for 52 million students. There is nothing, including the disinfectant, that is free. And so we need this thing called the HEROES Act that passed the House and is now sitting on Mitch McConnell's desk. Billions of dollars that would go like this to public schools. They had no problem passing billions of dollars for Shake Shack. And yet Orchard Elementary, not so much. So we have part of the solution. This isn't all about money, but there is no way we're going to be able to follow the guidelines without having federal assistance, the same assistance they gave to corporate America. They don't want to give to public schools. And so it is why we're going to keep telling you to tell your senators to push Mitch McConnell to get off of vacation and pass the HEROES Act. I could go on like this for about 42 years. I have been upset with Donald Trump probably every day of his, since his campaign. This just feels different to me. It feels like he is using students. It feels to me that he is trying to cause intentional chaos so that we can't open schools safely, that we don't even have a chance to open schools safely. And so you have the same questions I have. What kind of rights do I have? What kind of responsibility do I have to my students? And who's with me? Am I all alone in this? And so we have asked the most popular person at the NEA, because Alice O'Brien, if you know her, you know why we go to her. She has this very calm, Alice, you always look calm. I've never seen you lose your temper. I lose mine 3 times a day. But you always stick to, here's what you need to know about what the law says, your legal responsibilities, your legal rights, because we can build a lot of advocacy around that. So I want to welcome Alice and turn the microphone over to you. Alice tells me that she's had thousands of calls and emails, because we said, if you know your question, send it in advance, and thousands of you did. So I'm sure, Alice, you're going to answer every one of the 3,842 calls or questions that you said you've already received. So I should give you some time to do that. Hermanos y hermanas, brothers and sisters, this is the smartest woman I know, Alice O'Brien.
Thank you so much, Lily. Thank you for your advocacy, and thank you everyone who is on the call right now. We are going to cover a lot of ground because we know you have millions and millions of questions. As Lily said, we received over 3,800 questions from members registering for this call. We have crafted the agenda for this call to answer as many of those questions as we possibly can. And I know that we are not going to hit every single person's questions. And I also know you're going to have more questions as we go through this, because it's complicated and difficult and very serious. So if and when you do have questions, put them in the question box. And we are going to go through all of them and answer all of them. How we'll do that is we are going to, after this call is over, put all the questions together on particular topics like on accommodations and leave and mask and you name it, and do short written guidance pieces that will be posted on this site that you see on the screen right now, educatingthroughcrisis.org. So here's our agenda today, based on your questions. First, we want to talk about what the health experts tell us needs to be in place for schools to reopen safely. Then we're going to talk about accommodation and leave rights that individual members have. We're going to talk about worker compensation and waiver issues. And we're going to talk about strategies for bargaining and advocating for safe schools. I'm not going to do all this alone. On the call with me today are 4 of our resident experts on these issues. So NEA Collective Bargaining and Member Advocacy Director Dale Templeton will be speaking a little bit later, as well as NEA Deputy General Counsel Jason Walta, NEA Staff Attorney Kira McNett, and NEA Collective Bargaining Specialist Marcy McGrid. I'm going to start off today by reviewing the guidance of health experts as to when schools should reopen and with what protections in place, and then I'll turn it over to Kira to talk about the accommodations and leave issues. She will then turn it over to Jason to address waiver and liability issues, and then Marcy and Dale will close it out with bargaining and other advocacy strategies. So before we get started on all that, I want to turn this over to Dale for a moment to introduce herself. Dale.
Thank you, Alice. I really appreciate it. Good afternoon, everybody, and thank you for joining us. And thank you for all the work that you do for our children, especially during these very challenging times. For those of you that don't know me, which is most of you, I am been at NEA now for 7 years, but prior to that, I spent my career working for our affiliate in Maryland, advocating for our members. As Alice previously stated, we know that you are deeply concerned about the opening of schools and what it will mean for you and your students, but we hope that the information that you take away today will help alleviate some of those concerns. For all of us, COVID-19 poses unprecedented challenges, and the way we address those challenges will vary from state to state and district to district. And we promise that we will continue to do everything that we can to support our local affiliates, state affiliates, and you, our members. And I'm going to turn it back over to Alice.
Thanks so much, Dale. We are going to start with what's the most important criteria for schools to reopen, which is health and safety. NEA's position has been and will be that the absolute preconditions for schools to reopen are, number one, a scientific consensus, not a political judgment, a scientific consensus that the virus has been sufficiently contained and that the local health infrastructure exists to effectively address current and future outbreaks, and that there is a plan in place that works to contain the virus. That includes testing, effective contact tracing, and the ability to isolate cases, both within the school community and in coordination with the broader community. Now, those criteria are not met almost everywhere in the United States right now. And that changes, week by week. But as of July 8th, 2020, 2 days ago, none of the orange shaded states on this slide had a downward trajectory of new cases over the prior 2 weeks. They were all trending up. And what that means is 43 of the states in the country currently fail the threshold CDC criteria, the Centers for Disease Control criteria for reopening. In those criteria, you can see them all on the screen. There are 6 of them, which states are supposed to meet before they begin the reopening process. And the very first one is that the number of newly diagnosed COVID-19 cases is trending down. Now, there's lots of talk right now that countries all over the world have reopened schools, countries in the EU have reopened schools. But if you look at the data, they reopened schools after the virus, the pandemic, was under control, when it was contained to a significant degree. So these are just two examples, Denmark and Germany. And both of them, you can see the arrows point to where schools reopened. In both countries, schools reopened gradually, only under very strict physical distancing and healthy hygiene protocols in place. And they did where that after and only after there was a sharp downward trajectory in new cases. That is not where we are right now in the United States. Once the threshold conditions exist, once the pandemic is controlled, contained, schools must follow the CDC guidelines to limit the risk. And I'm going to talk through those very quickly because you have to know what they are so that you can advocate at the local level and at the state level to make sure they are followed. There are three overriding considerations in the CDC guidelines. Number one, students and staff who are at higher risk for severe illness must be protected by providing them options for telework and distance learning. That's number one, an overriding consideration that needs to be addressed off the top. Number two, schools and campuses need to put the basic protections in place to prevent the spread of COVID. We call these the 4 Ds: distancing, deterrence, disinfection, and detection. And we'll talk through all those too. And number three, make sure students and staff who get sick don't come to school, and that they're encouraged not to come to school, and that they have the leave and support not to come to school. So what are these 4 Ds? Physical distance, you've heard a lot about this. The CDC recommendation is 6 feet between all people, which means in a lot of schools, hybrid schedules, staggered schedules are going to be a necessity because there is no other way to create the distance required for safety. Deterrence, that means healthy hygiene, masks, ventilation, eliminating shared supplies and equipment, disinfection of buses, schools, and equipment, and detection. That means screening, isolating sick students and staff, and closing as needed in the event of an outbreak. So the physical distancing recommendations, these are the hardest and the most costly for schools and campuses to implement. The thought is you want to limit, just like all of us have been doing for the last several months, limit as much as you possibly can the number of people that individuals come in contact to. So you want to ensure your student and staff groups are as static as possible, that space, seats, and desks at least 6 feet apart. You want to cancel field trips, intergroup events, extracurricular activities. You want to restrict non-essential visitors in the schools, just staff and students. Close communal spaces, lounges, dining halls, cafeterias, playgrounds. Otherwise, you need to stagger the use, severely limit the number of people, the number of students who are using them at any one time. You obviously need to stagger your arrival and departure times and create distance between students in class. Complying with these is difficult. At the elementary school level, it's difficult for developmental reasons. And at the middle school and high school level, it's difficult because of how instruction is structured, and that students now move between classes with a lot of interchange between lots of different groups of students. But the CDC recommendation is to change that and to severely limit how many people, both staff and students, come into contact with over the course of the school day. In terms of deterrence, the CDC's guidance is it's what many of you have been telling your students for many, many years now. People need to wash their hands. They need to wash their hands repeatedly, regularly, and properly. They need proper cough and sneeze etiquette. The CDC says all staff should wear masks, and it encourages all students to wear masks unless developmentally or physically they cannot do so safely. And it's clear from the CDC guidance that in almost all cases, their view is that students can wear masks, can and should wear masks. There need to be adequate supplies in all schools, not just the rich schools, not just the schools that are well funded, but the schools in all communities that have soap, hand sanitizer, so that everybody can comply with healthy hygiene practices necessary to prevent the spread of the virus. And ventilation systems have to work properly and bring in as much outdoor air as possible. Where windows can open, windows need to be open. That's particularly true on buses. We want air to be circulating in order to prevent the spread of this airborne virus. As to disinfection, again, the CDC's recommendations are pretty straightforward. Frequently touched surfaces and used surfaces in the school and on school buses need to be cleaned and disinfected at least daily, as do shared objects, toys, games, art supplies, manipulatives between uses. And there are protocols, of course, for the correct application of disinfectants, and of course, they should be kept away from children. Detection, the CDC urges that screening systems be put in place for both students and staff. They are not specific as to what those screening mechanisms should be, whether or not they should be advising parents to check students at home, or temperature screening at the school, in front of the school, and or symptom checking at the school. Screening is difficult in the case of COVID-19 because there are so many circumstances under which people are asymptomatic, children are asymptomatic, but do have the virus. And so screening is important, but it certainly, it will not catch all cases of a virus, even if it's enforced very strictly. And the community needs to be educated about COVID-19 and encouraged to stay home if they are sick and not to come to school. If students or staff become ill, the CDC advises that they should be isolated, that the staff who attend to them should have significant PPE equipment provided to them in order to safeguard those staff, that there should be procedures in place to get them home safely or to a medical facility, that the local health authorities should be notified, that the areas where the sick person was should be closed and they should not be used until they are cleaned and disinfected, that individuals who came in contact with that sick staff member or sick student be advised of the exposure and be quarantined until it's clear that they are safe as well. And the CDC recommends that when a COVID case is reported to the local health department and the local health department advises that the school should be closed because of either increased community transmission or in the event of an outbreak in the school, that the school should be closed. So all these Ds, people are talking about them as though we can do one and not the other, but it's clear from the experts that all four of them need to be in place. They are complementary and reinforcing. And if they are not all in place, the consequences are, and this is what the experts predict, that there will be outbreaks in schools and they will come relatively quickly. So there was a research study done by Mathematica for the Pennsylvania Department of Education that predicted, and they have caveats. They say, you know, we're making all these assumptions about what a typical school is, but they're saying for a typical school in our state, without safety precautions in place, like distancing and hybrid schedules, the average school in Pennsylvania would have 5 COVID infections within 5 days of opening. If all the precautions were put in place, all the CDCDs, they say the length the school could stay open would increase substantially, up to 10 to 15 times the 1 week prediction for a school without the protections in place. So beyond the CDC, there are state-specific reopening rules. The Virginia Department of Labor and Industry is developing a workplace safety rule for COVID specifically. Oregon has announced that it will follow suit. And there are a myriad of state executive orders that put in place health and safety protections related to the reopening of schools. Obviously, NEA and our affiliates have been actively involved in the effort to get these protections in place before schools reopen. So you need to know where your state stands, and I'm just going to provide you a very quick snapshot of potential protections you may have. Almost 3/4 of the states have workplace safety laws that apply to public sector workers, like workers in schools, workers in public higher education institutions. 26 of those states are OSHA plan states, and 6 adopt at least some of the federal OSHA rules. And you all know this, but OSHA is the federal workplace safety law that applies to private sector workplaces. And it creates, there are 3 things about it that are notable because the state OSHAs all follow suit to a large extent. Number 1, it imposes a general duty on employers to provide work and workplaces that are free from recognized hazards. And that general duty is enforceable through proceedings before OSHA. It's enforceable through administrative proceedings. And OSHA also has regulatory authority to address particular hazards by promulgating a standard as to how those hazards are to be addressed and contained in the workplace. The states that are blue on this map are all OSHA plan states. They're all states that follow that basic formulation for protecting public sector worker health and safety. The states that are blue on this map are states that follow the OSHA regulatory framework to some extent, at least as a floor. The states that are blue on this map, and this PowerPoint will be available to everyone as well, so don't feel like you have to write really fast, are states that have some kind of general duty clause in their state law, meaning public sector employers have a general duty to provide a safe workplace. And we do have states, a number of states, the ones in white, that have no state statutory law that provides a workplace health and safety in the public sector. But in those states, there are common law tort remedies which are available and which potentially provide a basis for challenging a school district or a college that reopens unreasonably without putting in place reasonable health and safety protections. And of course, as Dale and Marcy will talk about in just a bit, states that have public sector bargaining have very robust protections for health and safety and also for whistleblowers under the terms of those collective bargaining agreements. And states everywhere in the country, except for 2 states, provide protections for whistleblowers who are tenured teachers in the form of the tenure laws that prevent dismissals without just cause. So I'm going to pause there before we go on and ask Jason, who has been combing through the questions that you all submitted, if any questions have come in on these issues that we can answer right now. So Jason, what do you say?
Yes, I've got 3 questions for you that have come in mostly before the webinar. But one is you've been talking about the CDC standards, but aren't those about to change? And if they do, what protections will we have?
So that's a great question, and I know a lot of people did submit it. The CDC is under a lot of pressure, and this has been going on all spring from the White House to change, to modify, to water down in some respect their guidance for reopening and their guidance for reopening on schools in particular. The CDC director just yesterday came out and clarified that the CDC guidance that is anticipated to come out next week will supplement the current CDC guidance and will not change it. So our expectation is that the basic rules that I just talked to you about are the rules that will hold, and what the CDC will be doing next week will be supplementing and expanding upon those.
Okay, a second question. Haven't some groups like the American Academy of Pediatricians come out in favor of a more relaxed set of standards? And why shouldn't we follow those?
Also a really good question. You all may have heard that, I think that last week, the American Academy of Pediatricians came out with a statement on school reopening, which made the case that it is better developmentally and for health reasons for students to be in school, which we all obviously agree with as educators and people who support educators. And that statement was seized on, I think, with political motives by the Trump White House and trumpeted as a statement that the pediatricians support reopening schools regardless of any circumstances, any health and safety orders. But that clearly is not true. The president of the Academy has come out and said that the Academy does not support reopening under any circumstances. And just this morning, and we will post it so people can see it, a joint statement was released by the Academy saying that they do not support reopening of schools where local health authorities advise against it, where there are rising community transmission rates, and that they support schools putting in place the necessary health and safety protections before reopening.
Okay, a third question. Both President Trump and Education Secretary DeVos have threatened that schools who don't reopen will lose federal funding. Can they do that?
So Lily was saying you should never go to President Trump for medical advice, nor should you go to him or Betsy DeVos for legal advice. They do not have authority to cut off federal funding to schools in order to force them to reopen over the local judgments of health authorities, of school authorities as to what the appropriate course is in the local community. Trump is not going to bully educators and the American community into reopening schools when it is unsafe to do so. And there are a couple things you need to know about why his threat is so idle. Number one, 90% of funding for schools comes from states and localities. So the federal government can't touch that at all. Number two, the federal funding that does flow to states and localities flows under statutes that Congress has passed. And the president and DeVos do not have the authority to rewrite those statutes. And should they try to do so, we will see them in court. And I'm going to go out on a limb and say that we will win because they do not have the authority to rewrite those statutes to suit their political agendas and hold schools hostage for federal funds in order to reopen to serve their political needs. So I think we should probably move along. So what we're going to do now is we will turn to the individual accommodation and leave questions that so many of you had. And Kira is going to take us through that. Kira?
Thank you so much, Alice. So I'm going to be speaking about educator rights to accommodation and leave. And you know, looking at all the questions we've received, so many of you had concerns about your specific circumstances that may make in-person instruction more risky for you or your family. And the general categories that we saw were a medical condition that increases risk of serious illness or death from COVID-19, living with an individual who's at high risk, older age, pregnancy, and childcare responsibilities. Those were the main kind of categories of concerns that we saw. And I'm going to address all of those. So the important thing here is that you do have rights. Under federal law, there are individual rights that may apply, and I'm going to go over the federal laws today, especially focusing on the first one here, the Americans with Disabilities Act. But I'll also mention where there are other federal laws that may come into play, Pregnancy Discrimination Act and the Age Discrimination in Employment Act, or ADEA, when it comes to health conditions, and the FMLA, the Family and Medical Leave Act, and what's called the Families First Coronavirus Response Act, or the FFCRA, and workers' compensation. And those are all relevant when it comes to questions about leave. And it's important to keep in mind that states and even some local level laws may provide more protection than federal laws. You may also have collective bargaining agreements, or MOUs, and school district policies that apply to your specific circumstances. So it's always important to check with your local and to consult with legal counsel at the local and state level on any individual issues you may have. So if you have a health condition and you want to know, do I qualify under the ADA? We're hearing from many members about a lot of people who have health conditions that they may never have previously found disabling, that they were able to manage and do their jobs without even thinking about. But in this pandemic, there are many medical conditions that may present real challenges for returning to classrooms. So if you have a health condition and you want to know whether you qualify for an accommodation under the Americans with Disabilities Act, the ADA, the first question is whether your condition qualifies as a disability. And to be clear, disability here is a legal term, not a medical one. Under the ADA, it's defined as a physical or mental impairment that substantially limits one or more major life activity. And what qualifies as a disability is interpreted quite broadly. While we may ordinarily think about a disability as being something major, permanent, some kind of condition that is long-lasting, under the law, it can be something that's relatively minor and transitory, meaning it only lasts for, say, several months. So turning now, with that in mind about what is a disability, we look at the conditions that the CDC has recognized are known to increase the risk of severe illness from COVID-19. And you can read the list of conditions here for yourself, but looking at all of the guidance from the EEOC, the Equal Employment Opportunity Commission, and court cases on ADA disabilities, all of these conditions may very well be disabilities. I've highlighted obesity here because there is some question about whether obesity alone will be seen by a court as a disability. So it's something to think about whether you may also need to identify other physiological causes of a disability. But at the very least, if you fall into this high-risk category on the CDC list, you should be able to at least request an accommodation. And the CDC also says that the following conditions may increase risk based on what is currently known. I've highlighted pregnancy here. I mean, there's obviously a number of other conditions that many people suffer from and would not ordinarily have issues at work, but now find themselves to be particularly vulnerable because of the virus. And I mentioned pregnancy here. We're going to discuss that in a minute, but also smoking. That's the only thing on the list that I see that wouldn't qualify as a disability. But in addition to all of these conditions listed by the CDC, there may also be other health conditions that would apply. So you would have to talk to your doctor about that. Mental health conditions may also qualify as a disability. It's important to note that the ADA covers both physical and mental impairments. Many people, as we all know, are experiencing high degrees of stress related to COVID. But for individuals with some diagnosed mental health impairments, it may cause particular difficulties and require accommodations to work conditions. So if you have a health condition that seems to qualify as a covered disability under the ADA, what does that mean? The ADA requires employers to provide reasonable accommodations to qualified individuals with disabilities, unless providing an accommodation would be an undue hardship on the employer. And a reasonable accommodation means some kind of modification to the job or to the work environment that will enable the employee to continue to perform the essential functions of the job and will allow them to enjoy the benefits and privileges of employment. When we're thinking about accommodations, especially in this context of the pandemic, it involves a number of different factors. At the top of the diagram here, you have the essential functions of the job, and that's going to vary from job to job. And even in some cases, the district may be able to say that the essential functions of the job have changed. For example, where teachers have been teaching remotely, being physically present wasn't, at least temporarily, an essential function of the job. But being physically present may now be an essential function if schools reopen and there isn't a distance learning option. Then you look at what types of exposure to the virus you may have in your particular job and how that may interact with your medical condition. And then in considering what accommodations may work, you're thinking about how to reduce the risk based on the types of exposures you have and your medical condition. And then back to whether these accommodations, modifications to the job or the work environment, will allow you to carry out the essential functions of your job. And the point here is that an ADA accommodation is really an individualized determination that looks at your condition, your job requirements, and what modifications can reasonably be made for you. On the right, we've listed some possible accommodations here that are just possibilities based on what the CDC has recommended in general for risk reduction, and many of which Alice covered in her remarks. But I just want to briefly highlight temporary leave here as a possible accommodation, because asking for open-ended leave as an accommodation is almost always a big problem in ADA law. So that's something to be aware of. And even though there are lots of unknowns about how the pandemic is going to continue, where it may get worse, or when treatments or a vaccine may be available, it's best when asking for an accommodation to put leave in terms of some time frame, like until certain safety measures can be put into place, or until community transmission drops below a certain level or a vaccine is available. As far as how you go about requesting an accommodation, first, definitely check with your local association or state affiliate, as they may be able to help you. Under the ADA, you can request an accommodation at any point that you need one. You don't have to use any magic words, and you don't have to put the request in writing, but it's always a good idea to follow up in writing, like by email, for your own records, if nothing else. And just one note here, as we're seeing this in some places where school districts are sending surveys specifically asking employees to identify whether they have particular medical conditions, some of these kinds of medical inquiries might be prohibited under the ADA. And if you're not requesting an accommodation, your employer can't require you to disclose your health conditions. And it may actually not be in your interest to volunteer that information unless you're specifically seeking an accommodation. The question of what medical documentation do you need? The ADA does not require you to provide documentation in the upfront making a request for an accommodation. But if your employer asks for medical records, you should try to provide whatever is requested, as long as it is relevant to your particular disability and in consultation with your doctor. So going back to our accommodations diagram from before, specifically when talking to your medical provider, their understanding of what you need, what your job requires, and what modifications may be possible is really important to getting a helpful note from them. Any doctor's note should have a statement of your medical condition and that a reasonable accommodation is necessary. And it should have some specifics about your limitations or what your provider recommends to reduce your risk. And consider with your medical provider whether there are different possible alternative accommodations that may continue to allow you to perform your job. What does the employer have to provide? You've asked for an accommodation. Now what do they have to do in response? They're required to consider the request and to engage in what the EEOC refers to as an interactive process, where the employer and employee work together to try to find an accommodation that will work. Ultimately, the employer just has to provide a reasonable accommodation. It doesn't necessarily have to be the one that you asked for. And keep in mind that the employer can claim that an accommodation isn't possible because it would be an undue hardship. but that's on them to show. What do you do if your employer denies your request? First of all, it's always a good idea to get more information about why and try to fix the problem if you can. If you're told that it's an undue hardship to provide it, ask for more details about why that is and try to discuss possible alternatives. If the denial is because they say they don't have enough information about your medical condition or why you need the particular accommodation, try to provide more information if you can. You should report any denial of an accommodation to your local, but also be aware that there are strict timelines for under the law in which you have to bring a claim if you want to file a complaint with the EEOC or with your state agency. And finally, it's important to know that it's illegal for an employer to retaliate against you for seeking an accommodation. So if you find that you're being treated worse than other employees or actions are taken against you after you make a request, be sure to object to this and consult with legal counsel about filing a complaint. The next kind of category of concerns that we're hearing is, I'm worried that my age puts me at higher risk. And many members are concerned about this. The CDC notes that the risk of severe illness increases with age. However, age itself, if there's not some underlying health condition that you can point to, is not a disability. So there wouldn't be any protection under the ADA. The federal law that prohibits age discrimination does not have an accommodations provision like the ADA, but it also doesn't prevent employers from accommodating older workers. And this is something that the EEOC has made clear in its guidance on COVID. Employers can voluntarily accommodate older workers, for example, workers over 40, and that would not violate the Age Discrimination Act. Pregnancy is another issue that's come up a lot in thinking about members who may need accommodations. As I noted before, pregnancy itself is not a disability, but many pregnancy-related conditions are considered disabilities, and some states have their own pregnancy accommodations laws. So if you're pregnant and you're worried about the risk of exposure to COVID, you should talk to your doctor about what accommodations are recommended. I live with someone who's high risk. This is a question we get a lot. What are my options if I'm not high risk, but I live with someone who is? And I'm worried about being exposed to COVID at work and exposing my spouse or my parent or a child who is high risk. Unfortunately, this is an area where, at least under federal law and the state laws that I'm aware of, there aren't many protections. And the ADA does not require an employer to make accommodations for an employee to protect a family member with a disability. There's some protection under the ADA in that you can't be treated worse or harassed because you have a disabled family member, but accommodations just on the base of that family member's disability are not required by law. The Family and Medical Leave Act, FMLA, may provide an option of taking unpaid leave, but only if you're caring for a family member who has a serious health condition, as that's defined under the FMLA. And there are other requirements to qualify for FMLA leave, like having 12 months and 1,250 hours of employment in the year. Really though, this is an area where you particularly want to look to your local and talk about what may be available under existing agreements with the employer, or what may be able to be part of a reopening plan that takes into account the needs of employees who have someone high risk at home whose health they're trying to protect. And again, the other big issue that came up a lot during the spring and will likely be a major concern in the fall, particularly in any states where there are hybrid models of online or in-person, or some schools or childcare centers are open and others are not, is the issue of childcare responsibilities. There is actually, at least until it expires at the end of this year, a federal law that provides for paid family leave for the limited purpose of caring for a son or daughter whose school or daycare is closed due to the pandemic. The emergency FMLA expansion is part of the Families First Coronavirus Response Act, and you can take up to 12 weeks of leave, 10 of which is paid at 2/3 your regular rate of pay. I won't get into a lot of the details about the FFCRA because there's actually another full webinar on leave under this act, and that's available along with frequently asked questions about it on NEA's website, which was referred to before, the educatingthroughcrisis.org site. One important note here is that you may be able to use this emergency childcare leave intermittently, meaning a few hours a day or a couple of days a week. And this is something that has to be negotiated with the employer on a case-by-case basis, but it can be a really important option for educators who are trying to juggle work and childcare. So what are the options if you can't be accommodated? Again, without getting into too many details about the FFCRA, which you can get more information about in the separate webinar and materials, I do want to highlight it again as a possible source of paid leave because it includes emergency paid sick leave. And as of now, this is set to expire at the end of this calendar year, but it does provide 80 hours of paid leave for certain things related to coronavirus, and it can be used before you use any other leave. So that's important. Just a reminder that there's other options for leave, the FMLA, if you're covered under this federal law or under your state's FMLA law. And of course, consult with your local or your state affiliate about leave you may have under an agreement with the employer or under district policies, including possibly disability leave provided by state law or employer policies. And what if I'm exposed to coronavirus while working? What are my options for taking leave? Again, all of these leave options may be available if you're exposed to COVID while working. And in addition, the emergency paid sick leave under the FFCRA would be available if you're under a government quarantine or isolation order, or you've been advised by your doctor to self-quarantine, or you're experiencing symptoms of COVID and you're trying to get a diagnosis. One question that we got many, many times was what happens if I contract COVID at work? Are my medical bills and leave covered by workers' compensation? It's true that workers' comp is where employees are ordinarily expected to go if they're injured or become ill because of something in the workplace. And whether you may be able to get workers' comp is going to depend on state law. In general, as things stand in most of the country right now, unfortunately, it's difficult to get coverage for COVID exposures at work. But this is an area where state laws and policies are evolving very rapidly, so definitely check with your local on this if this issue comes up. And in general, some practical guidance on workers' comp claims, you definitely want to notify your local if you contract COVID at work. And be aware that causation is usually going to be a strongly contested issue when it comes to COVID. So it's a good idea to document as much as you can about, for example, any previous COVID test results you've had, the limits of your contacts during the period where you may have become infected, who else were you around, any possible sources of workplace exposure, meaning any known positive cases in the school, and of course, all the medical records, including when, and especially when your symptoms started. And you should consult with legal counsel who knows your state workers' comp law. This is a really thorny area right now. And with that, I'm gonna turn it over to Jason Walta.
Hi, I'm Jason Walta. I'm the NEA Deputy General Counsel. And I'm gonna talk about whether schools could require educators, students, and the public to waive claims of liability for contracting COVID at school. Many of you sent questions about this for the webinar, and it's an issue that's been a hot topic for discussion as we contemplate a reopening of schools. And in fact, we've already seen a few instances of schools trying to use waivers like this. One school was asking teachers to sign a waiver that released the school from any liability if the teacher contracted COVID at work, and it asked the teacher to release the school from liability for any of the teacher's family members if they contracted COVID from the teacher. Elsewhere, we've seen schools try to insulate themselves from liability by posting notices like this one. This is one that was directed at the public attending a school event in Montana. I'm not going to make you read that entire wall of words there, but the long and short of it is that it warns generally of the risks of contracting COVID and tells the attendees that they've assumed those risks by remaining at the event. And so the question is, can schools use these waivers and notices to release themselves from liability to those who contract COVID at school? And can educators be required to sign them? Now, if we can move to the next slide, for school employees, we think the answer to both of these questions is no. These waivers are not effective and they cannot be required as a condition of work. And there are several reasons for that. The first is that workers' compensation would likely provide the exclusive source of recovery for a teacher who contracts COVID at work. And it is absolutely clear that employees cannot be required to waive their workers' compensation rights. Second, setting aside workers' compensation laws, you are generally entitled to sue an employer that intentionally injures you. And it is against public policy to have an advance waiver of those kinds of intentional harms. Number three, you can't waive the rights of other people like your family members. Four, to the extent your state has laws that regulate workplace safety, the laws that Alice discussed, your protections under those laws aren't waivable. You can't just sign them away. Fifth, if you are an employee with a disability that's covered either under the federal Americans with Disabilities Act or state anti-discrimination laws, you can't be required to waive your rights to protection or an accommodation for your disability. Number six, for tenured teachers, you can't be required to modify your tenured contract of employment on some kind of threat of termination for failing to sign one of these waivers. And finally, in states with collective bargaining, a school generally cannot unilaterally change the working conditions, unilaterally change the protections that you have at work without at least bargaining first with your union. And so that's kind of our answer as to waivers that are presented to educators and other school employees. But what about those notices that are posted outside of the school? Well, those notices wouldn't be any more effective against a teacher than a signed waiver would be. And we've just laid out all of the reasons why those signed waivers are improper. But if these notices are directed at the general public and possibly towards students, do they do anything? And there the answer is a little more complicated. For a student or member of the public, their legal recourse against a school for contracting COVID would not be workers' compensation. It would more likely be a tort claim like a negligence claim. And even without a waiver or disclaimer, schools often have immunity under state law for those kinds of tort claims. Still, schools wouldn't be able to use liability notices against students because they are minors and they're legally obligated to attend school, so that they don't have a choice about whether to assume the risk of contracting COVID or not. But schools might be able to limit some of their liability to other members of the public, assuming those people saw the notice and accepted the risk, but this would be a highly case-specific question that would be difficult to answer without knowing all of the circumstances. Now, at the end of the day, waivers are not likely to be effective in most circumstances, and certainly not when it comes to educators. And that is why employment side lawyers, the ones who advise employers generally and school districts in particular, they are advising against these kinds of waivers. What these employer side lawyers are telling their clients is that these waivers can backfire against employers and have unanticipated consequences. For one, they could discourage employees from returning to work, and without educators returning to schools, you're not going to reopen. And second, they could create bad publicity. More about that in just a second. So what should you do if you're presented with a waiver like this? First, immediately notify your local association and your UNISERV director. You, our members, our educators, you are our eyes and ears on the ground for these situations. And your local, your state affiliate, NEA can't respond to them unless we know about them. Second, do not sign a waiver without consulting your local association. Make sure they know about it. Don't sign a waiver without sharing it with them. Finally, work with your local association to publicize these waivers. I mean, one of the strongest weapons we would have in this situation is the public relations backlash. And with these waivers, with notices like the one I showed you earlier, there's an acknowledgement by the school that it can't ensure a safe workplace or learning environment. And so they really risks bad publicity that we can tap into. Now, I believe there were some questions to field about the individual employee protections and employee liability. Alice.
Yeah, so real quick, we had many, many questions about accommodation and leave issues. One, and Kira, you covered a lot of them. One question that has come up though, which would be helpful to hear your thoughts on, is what are the rights of somebody who's told by the employer to go home because they've had an exposure at work to somebody who has COVID? Either a student has COVID and they're told they were in your class and you need to go home, or a colleague has COVID.
So Alice, the first place I would look on this is the federal law that we were talking about that provides emergency paid sick leave under the FFCRA. You're entitled to up to 80 hours. It's 2 work weeks of paid sick leave for a variety of COVID-related reasons, including a state or your own medical provider's direction to self-quarantine. And looking at the whole purpose of the law, which is, to help protect public health and allow people to be out of the workplace when they may be contagious, whether or not they're experiencing symptoms. If you were exposed to somebody, there's a possibility that you're contagious. And so it should cover a situation where your school says someone in your class tested positive and you're directed to stay home for 2 weeks. You can use this FFCRA sick leave before you use any other sick leave or any other type of leave. The law is very clear that your employer can't require you, if you qualify for this leave, to use other leave first. So that's the first place I would always look. There is a lot of misinformation and confusion out there about this law, especially because for private employers, there are a lot of limitations. Like it doesn't apply to companies with more than 500 employees. But those limitations don't apply to public sector employers. So really, almost all NEA members should be covered by this law and should be entitled to these paid sick leave benefits. And of course, all of the questions about what kind of leave you would use if cases come up in the school and some staff have to quarantine as a result, that should be part of the reopening discussions.
And Jason, a question that has come up, we know everyone is so very concerned, and rightly so, about their health and safety and the health and safety of their loved ones. What if someone gets sick, brings COVID home to someone who has a condition that puts them at high risk, and that person becomes very ill and even dies? What's the remedy?
Well, the remedy for an educator, for someone who does get sick at work, their remedy would generally be under workers' compensation, and I'll get to the family member in a moment. But workers' comp generally provides the exclusive remedy for injuries or illness sustained at work, and it provides kind of a limited remedy that covers medical costs, lost wages, and a kind of a modest death benefit. And as Kira mentioned, there could be all kinds of difficulties in claiming workers' compensation if you contract COVID. There's a big question about whether COVID is even covered by workers' compensation laws. Things like the flu and catching colds at work generally aren't, but certain occupational illnesses are. And then there's a big kind of causation question about whether you in fact did contract COVID at work. And there's a lot of lobbying and policy work that's going on trying to address that. And some states have come up with a solution to say that COVID is covered by workers' compensation, and that you're presumed to have contracted it at work if you're a certain kind of frontline worker. For a family member, the options would be some kind of negligence claim, some kind of tort claim. But as I said earlier, school districts often have fairly broad immunities from these kinds of tort claims. And this is going to be a very state law dependent question But one of the things that you would have to confront if you had a family member who got ill, who was injured, or who even died from this, is that any suit that you might have against a school district, you would have to confront these immunity issues that schools have under state law.
Thank you. So I do want to remind everyone, I see just during the course of this town hall so far, we've gotten almost 2,000 more questions. So we are going to be answering them, and we are going to be posting the answers on the Organizing Crisis URL site, and I'll show that to you again at the end of this presentation. It's also in this PowerPoint, and the PowerPoint will be posted as well. Thank you, Kira and Jason. We're going to turn this over to Dale and Marcy to talk for a bit about collective bargaining rights and the protections they provide.
Thank you, Alice. The NEA Collective Bargaining and Member Advocacy Department is staffed by experts in the topics including pay, pension, health benefits, collective bargaining, contract language, and policy guidance. We support affiliates and meet member needs, including those states that don't have bargaining rights as well. From the outset of the COVID-19 pandemic, we have worked with NEA state and local affiliates providing guidance and responding to COVID-19 questions to help with members. And some of that guidance we've worked across the department at NEA and evaluations, distance learning, hazard pay, and many of the topics that we've already covered. In this next section, we're going to share with you bargaining and advocacy strategies you can engage in with your local associations that can protect your health, safety, and security. I'm going to turn it over now to my colleague, Marcy Magid. Marcy is one of our senior collective bargaining specialists, and she's going to talk to you about some of those strategies. Marcy?
Thanks, Dale. Hi, everybody. I'm Marcy Magid from NEA's Collective Bargaining Member Advocacy Department. So as Dale said, we're going to be addressing the bargaining and advocacy strategies. I know that many of you do live in states with bargaining statutes, many of you don't. So we're going to cover everyone, but we're going to start with talking about bargaining laws. So as Alice said before, most states that are covered by collective bargaining statutes cover salary, benefits, and working conditions. And obviously, health and safety is one of the major working conditions. On the screen, you'll see a very strong example of just general language. We recommend, it's basically a baseline. We recommend that if your contract is about to expire, that you want to add or strengthen your health and safety language, and you could use this as a start. You can also include more specific or detailed language. We urge you to work with your local and your UNISERV to basically strengthen this language, not just for COVID-19, but just in general. If you don't have existing health and safety provisions in your contract, your local may also want to negotiate a memorandum of understanding, or MOU as we call it, to cover health and safety issues. It really depends on your local situation. Next slide. So we know, as I said before, that many educators unfortunately are not covered by collective bargaining statutes. And in those states, it's really crucial that you use another strategy to protect your members, and that's using health and safety committees. Health and safety committees are also very important and very useful also in collective bargaining agreements, so it covers both. As you see on the screen, you can tackle some of these issues that Alice has talked about before. And you can address them in health and safety committees or in MOUs. It's the social distancing, making sure that members and students have the PPE equipment and also being able to wash their hands and have hygiene products, the procedures for disinfecting and sanitizing, and the proper ventilation. Next slide. Again, I want to just add these are samples, but we're just sort of giving you examples of how you can utilize these mechanisms. The other advantage of health and safety committees or other kind of language is you can develop contingency plans if the student or staff members contract COVID-19, provide mental health supports for student and staffs, create these special protocols. incorporate the racial and social justice into policies and actions. Basically, all the issues that the prior speakers have addressed. Next. So with labor management committees, there are several reasons why we recommend them. We find that they're one of the most useful means of effectively engaging with management, both in bargaining and non-bargaining environments. And the committee can help protect educators and students and their families. And it also ensures that educators, as the frontline employees, get their insights into how the schools or colleges are going to operate after, in COVID-19. The committee structure is also really well suited to deal with the constantly evolving nature of COVID-19, and also to address as the different guidelines and policy statements come out from the government and states. Locals can either establish or repurpose an existing committee. We know that many locals might have a wellness committee or some other kind of structure. It should include all educators, no matter what your career path. And again, as we've said before, it should either be included in your collective bargaining agreement or an MOU. We think it's really, really important that these labor management, health and safety committees are basically incorporated in perpetuity for your local. It's not something just for COVID-19. Obviously, a healthy and safe workplace is important all the time, and it should be the norm. And it can address all the issues that we've talked about, whether it's return to in-person instruction or future closures. Next slide. Another really important recommendation is that you try to incorporate having a local level health and safety committee at every school, campus, or other work site. It's really important for each committee to be able to monitor and address the ongoing developments and circumstances at each workplace. Obviously, it could be not even withstanding COVID-19. You could have mold or ventilation issues at one school, and another school in the same district can be totally fine. Similarly, you may have different issues for elementary school than you would at secondary schools. So it's also really good for engaging members, within the building or the community. As far as community and student, I'm not done yet. Well, I'll go ahead. I know we're running through time. So for the community and student engagement, for those that might have more advanced labor management committees, you want to consider involving student or family or community stakeholders. It really provides, those additional stakeholders provide really helpful and knowledgeable input to your demands for a healthy and safe environment. And it also really helps leverage some of the association's demands. And as we always say, students' learning conditions are educator working conditions. So it's important that those considerations be taken into account. Next slide. Again, for those of you who may not be familiar how labor management, health and safety committees work in general, it also just on a broader sense monitors the health and safety conditions of the workplace. So those can basically include things like the responsibilities such as reviewing inspections and injury and other reports, and also confirming that corrective measures are being completed. You can also make sure that and oversee that the kind of disinfectants and equipment and training is appropriate. So it's really very broad. Another really important aspect of what labor management, health and safety committees can do, especially in this environment, is to develop a communications plan so that you ensure the entire school community will be informed on an ongoing basis. It's also really useful when these communications come out from both the association and management at the same time, because everybody is hearing the same thing. And it just helps, everyone's trust level in these very stressful times. Next slide. The last point that I'm going to cover before I turn this back over to Dale, and my OGC colleagues mentioned this, is the importance of whistleblower protections. Again, it's important all the time, but especially under COVID-19. So we recommend that you can bargain or advocate for whistleblower protections at the state and local level. We want to make sure if any educators report anything, they're not retaliated against or experience reprisals. There might be some state and local worker safety statutes or ordinances that might provide such protections. We recommend you consult with your association counsel for those about that advice. Also, we recommend that you try to include whistleblower protections into your contract. And you can also include some principles about that in your labor management committee, even if you don't have bargaining. The National Employment Law Project, you see a link here. It's an excellent resource for developing whistleblower protections and additional information. So thank you for sticking with us as we're closing in a bit over an hour, and I'm going to turn it back now to Dale.
Thanks, Marcy. Thousands of collective bargaining agreements across the country are going to expire this summer and need to be renegotiated. This is a perfect opportunity to address the impact COVID-19 has had on all the issues that we've discussed today. And where we don't have contracts expiring or don't have the right to collectively bargain, we can bargain memorandum of agreements. We can advocate to address policy changes at the district level or even at the state level. Over the last several years, NEA and many of our affiliates have been engaged in a powerful community-wide crusades and organizing efforts to improve our schools and the communities surrounding our schools. In bargaining and non-bargaining states alike, parents, students, educators, and community activists have united to fight for everything from smaller class sizes, mental health supports, to school safety, racial justice, fair wages, and more. Bargaining for the common good, it expands the scope of bargaining far beyond what a traditional contract looks like. It includes student-centered issues and bargaining over issues that we term permissive subjects of negotiation. And we can use it in a non-bargaining setting because of the power that it brings by uniting the community, parents, and other unions together. And this is a great opportunity to have campaigns to address long-standing equity, health, and safety issues that are exacerbated by this pandemic. And then here, the next slide. And here are some of the examples of issues that can be addressed through this approach. Again, involving parents and community members at the initial phases of the planning and decision making, and then bargaining at the initial stages of when you're deciding on what those bargaining issues are going to be. That is very different than what we've done in the past in more traditional type of bargaining. And it's important that they're engaged in the reopening of schools so they're keeping them safe on an ongoing basis. So not just for a short period of time, but start developing those relationships so that that group is in place and that organizing is going on throughout the year. Engage students and their families to find out the experience that they had during the initial closings, the closures, and pay attention to the race and economic disparities that affected education during that time. Work with food service personnel and parents to determine the best and safest ways of implementing ongoing nutrition and food distribution to students. Seek additional school nurses, social workers, counselors, and other specialized instructional support personnel to support student needs. I know there's lots of talk about reducing the number of staff. We cannot do more with less. This is not a time to be reducing that staff, and having a bargaining for the common good organizing campaign that engages the parents and the community brings the kind of power that you need to make those kinds of changes. And I'll just go to the next. I think I covered this. I talked faster. And then we want to eliminate, this is an opportunity to limit foreclosures, eviction proceedings, actions against homeless and school-aged children. Given the strict regulations that students face in the environment, institute restorative justice practices rather than punitive disciplinary methods. Next. So those are just, Alice, can you just go back one? That's just some of the examples, but for more information on bargaining for the common good, there's two places that you can go. One is our website, nea.org/BCG. And in addition, we work very closely with our partners at Georgetown University Kalmanovitz Institute for the Working Poor and Rutgers University Center for Innovation and Worker Organization. And they have it's a bargaining for the common good initiative, and I've included their site as well. And again, we work on issues with them, K-12 and higher ed as well. And with that, I think we have time for questions, and we're going to try to answer some of those questions. I know we're short on time. And Marcy, because these are some of the things that you covered, I'm going to address these questions to you. We received many questions about specific health and safety provisions. This is one example. If we go back into the classroom to teach, should we bargain for PPE, masks, wipes, etc.? And also, what about testing?
Yeah, thanks, Dale. As everyone said, we've received a ton of questions on this. In general, we recommend working with your UNISERV to draft contract language or an MOU to address the return to school issues. They need to comply with the latest guidelines or your state health authority guidance. Also, as I talked about before, an active joint health and safety committee is really useful because the local and the employer can work together to address health and safety needs as they arise.
Thanks, Marcy. And question number 2, and it doesn't really address the health and safety directly, but it does somehow nuance how nuanced these issues can be. Does remote learning or blended learning affect class size as bargained in the collective bargaining agreement?
Yeah, this is really a great question because it shows just the nature and how complex all these issues are going to be when we talk about returning to school. So the answer really depends on the local context, including the relevant contract provisions, existing state regulations and the collective bargaining law. So again, we recommend that you consult with your local or your UNISERV. But again, this is one reason why we recommend that locals negotiate MOUs or get involved in a labor management health and safety committee, because that way you can address the locally based issues related to COVID-19 as they arise.
Thanks, Marcy. I know we have other questions, but as Alice said, we're going to be addressing them and making sure that they are, the answers to those questions are on our educationthroughcrisis.org, your rights. And with that, I am going to turn it back over to Alice. Thank you. Thank you, Marcy.
Thank you so much, Dale and Marcy and Jason and Kira, for all your expert advice. I hope that today's webinar answered many of your questions. I know it hasn't answered all of them, and I know some of the answers that we gave are not entirely satisfactory in that it's not all good news. But we want to make sure that you have the information straight up to the best of our ability to provide it to you when you're making decisions in this difficult time. I hope you heard also that NEA is with you. We will fight for you. We will fight with your state and local affiliates to protect your rights in every venue, in every way possible. The pandemic has had horrific consequences in our country. It has laid bare the legacy of institutional racism and white supremacy and has had devastating consequences on our communities of color in this country. We are determined to stand up for equity in school reopening, for healthy and safe schools in reopening, and when the conditions do not exist and local health authorities advise that schools should not reopen, we will stand up for the right of communities to make that decision for themselves, to protect themselves, their families, and their students. I just want to remind you one last time that all of the written guidance that we will be following up this webinar with will be posted on the site. I talked about it before, but I think I mangled the name. It's educatingthroughcrisis.org. You can go there to find the guidance, to find the recording of this webinar, this town hall. We also will be doing another series of this town hall next week in order to provide people additional information and provide people who could not sign on today with the information we covered today. If you have not yet done so, or your husband hasn't done so, or your kids haven't done so, go contact your senators. Tell them to support the HEROES Act. Give our schools the funding that they need in order to reopen safely. And you can go there by going to the same website, educatingthroughcrisis.org. Thank you so much for taking the time to sign in today. We appreciate it very much, and we are with you.